everyone. I know I'm on 5 minutes early. This is Jax West from Stephen Avery Project, Justice with Jax, MAM Gossip. And we are live today to go over Kathleen's reply to the state's response to her filing. Hold on a second. Let me get. You can get on. Why isn't it not letting me? There we go. I want to put the link into the comments. No comments yet. Why can't I see? There it is. Um, where you can read this for yourself. Um, it's also on Stephen Avery Project page. Since I've got screen share on, something I haven't done before, I'm like looking at the camera like I'm looking to talk to people when you're just seeing the filing. So let me scroll down to where we will start on page 4 of 19 in the introduction. And I forgot to bring glasses up here, so bear with me as I try to read this. The state's response fills in gaps with findings and analysis the circuit court never made, thereby highlighting that the opinion is fundamentally flawed. For example, the circuit court never analyzed Mr. Avery's pleading under State v. Allen to reach the conclusion that Mr. Avery insufficiently pled his claims. The state ignores this to repeatedly argue that the circuit court, quote, properly found that Avery did not plead sufficient facts, unquote. The state is correct that the, quote, only issue before this court is whether Avery pled sufficient non-conclusory facts within the four corners of his third section 974.06 motion to entitle him to a hearing, unquote. However, the state is incorrect in claiming that the circuit court denied him an evidentiary hearing on this basis. It did not. Rather, it improperly relied upon evidence outside of Mr. Avery's record on appeal, such as Brendan's, you can't see me now when I do go to show you the air quotes, confession, and false assertions that there was forensic evidence linking Brendan to the crime. Mr. Avery argued that the circuit court improperly merged the requirements of State versus Edmonds and made satisfying Edmonds contingent upon establishing the three elements of Denny. The circuit court focused disproportionately on the Denny motive element and ignored the independent materiality of the new impeachment evidence, which results from Bobby Dassey being in possession of Ms. Halbach's vehicle. The state compounds these errors by attacking the credibility of the witness who attested that he saw Bobby in possession of Ms. Halbach's vehicle after she was reported missing, without mentioning which authority requires Mr. Avery to address alleged facts outside his record. And then it has in parentheses Brendan Dassey's alleged confession. The state argues that because Mr. Avery failed to address evidence from a completely different case, his pleading fails. Lastly, the state accuses Mr. Avery of waiving his Brady versus Maryland claims on appeal in 1 to 2 milliliters of Mr. Avery's blood in the front area of the vehicle. Prior to its discovery on November 5, 2005, the vehicle contained Ms. Halbach, her clothing, electronic devices, camera, keys, and license plate. All of these items were placed in locations that implicated Mr. Avery in her murder. Now there is a witness who places the RAV4 in the hands of the state's primary eyewitness prior to its discovery by law enforcement. The Sawinski evidence also impeaches the credibility of Bobby's trial testimony, where he established an alibi for himself while implicating Mr. Avery in the murder. Bobby testified he left the property while Ms. Halbach and her vehicle remained on the property with Mr. Avery. This crucial testimony allowed the state to claim it was Mr. Avery, not Bobby, who murdered Ms. Halbach and concealed her vehicle on the property. This court described Bobby's testimony as follows. Certainly, this testimony bolstered the state's theory that Halbach visited Avery on that day and did not leave the Avery property thereafter. But absent this testimony, the state still possessed significant forensic and other evidence implicating Avery in a crime committed on his property. Now, the Sawinski evidence undermines the cumulative effect of the other evidence presented against Mr. Avery. Brian Dassey's previously submitted affidavit demonstrates that Bobby had no alibi and witnessed Ms. Halbach and her vehicle leave the property approximately the same time he left. Mr. Avery was in his trailer alone, and according to the state, he never left the property that afternoon or evening, which rules him out as a perpetrator. The cumulative effect of the many false statements made by Bobby have to be reconsidered in light of his possession of Ms. Halbach's vehicle. The state mistakenly contends that Mr. Avery failed to account for the bullet with Ms. Halbach's DNA on it, quote, that was shot from the gun in Avery's possession and found in Avery's garage, unquote. Mr. Avery has specifically addressed this allegation. Further, the state claims that Mr. Sawinski's affidavit only establishes that he, air quote, believes he saw Bobby. However, Mr. Sawinski was certain that he saw Bobby. The state also contends that Mr. Avery made no argument regarding Mr. Buresh's affidavit. Mr. Avery did, arguing that Mr. Buresh corroborates the Sawinski evidence. Thank you, Jocelyn. Next section, the materiality of Mr. Avery's Edmonds claim is not contingent upon satisfying the Denny test because the evidence is independently material. The state correctly states the standard for seeking a new trial based on the allegation of newly discovered evidence. The state adopts the circuit court's erroneous view that Mr. Avery's newly discovered evidence can only be material if it satisfies Denny first. Nevertheless, Mr. Avery has satisfied both tests. Mr. Avery provided sufficient facts to meet the Denny requirements. Mr. Avery agrees with the state on the law governing Denny, but not the state's interpretation of it. Mr. Avery pled sufficient facts to establish that Bobby Dassey had a motive for the murder. The state spent 3 pages addressing Dressler versus McCautry. Mr. Avery specifically relied upon Dressler for the court's finding that, quote, the pictures depicting violence were offered to prove Dressler's fascination with death and mutilation, and this trait of Dressler is undeniably probative of a motive, intent, or plan to commit a vicious murder, unquote. The violent photographs on the Dassey computer illustrate the same probative trait. Lastly, to clarify Mr. Avery's statement that this court, quote, pointed out in its opinion previously, unquote, that Denny evidence, quote, must be viewed in the aggregate, unquote, which the state claims is false, this court described viewing the evidence in the aggregate, exactly the standard articulated in State versus Wilson. I don't know what that meant either. The circuit court improperly found that Mr. Avery's evidence does not satisfy the Denny opportunity element. The state has improperly relied upon State versus Kreider to argue that Mr. Avery had to show that Bobby had the contacts, tools, time, and or other means necessary to have committed the crime and failed to do so. The state claims that Wilson supports the imposition of this burden on Mr. Avery. It does not. The Wilson paragraphs the state cites conclude that more evidence is required in the specific instance where vague allegations have been made about a third party hiring an unidentified hitman. In this case, Bobby has been specifically identified as having possession of material evidence in the murder case. The state copied from its original response to Mr. Avery's third motion for post-conviction relief a list of activities it claims Bobby would have been required to perform to commit the murder and plant evidence to frame his uncle. Mr. Avery rebutted all of these points in his circuit court reply brief. The circuit court improperly weighed Mr. Avery's direct connection evidence. The RAV4 is a material piece of evidence in the crime. Since the only similar Wisconsin case on this point is the case of State versus Williams, and then there's a footnote that says, using a common sense approach, the court found that the defendant's possession of the victim's car established probable cause to believe the defendants, quote, probably had committed a crime involving the murder victim's stolen car, unquote. This court can look to the Missouri case for guidance. There, the state presented other explanations for the discovery of material evidence, just as the state is doing here. The court rejected the approach, stating, the state argues that, we're not going to read that, because that's in that other case. And okay, so now when we get to Stephen's case, here the circuit court admitted that Mr. Avery has established Bobby's possession of the RAV4, but created other explanations other than acknowledging that Bobby had possession of the RAV4 sometime following his murder of Ms. Halbach. Bobby is now connected to material evidence in the Teresa Halbach murder case. The state improperly disputes the credibility of Mr. Avery's witnesses and his post-conviction lawyers. The state falsely accuses Mr. Avery's, air quotes, recent attorney of, quote, putting up a $100,000 bounty for purported witnesses, unquote, which it implies resulted in Thomas Baresh's affidavit. Mr. Avery's attorney did not put up a $100,000 bounty. Once again, the state alleges false facts outside of the record. Unlike the state, the circuit court correctly acknowledged, quote, the Sawinski affidavit, taken as true for the purpose of this motion, directly links Bobby to possession of the victim's vehicle, unquote. You're welcome, KJ. However, it stated, quote, there are other reasons that Bobby could have been in possession of the car that night, including that Bobby was trying to help hide evidence to protect the two individuals directly linked by forensic evidence to this murder and convicted of the crime, unquote. This is an untrue statement because Brendan Dassey was never linked to the crime by any forensic evidence, and Bobby's testimony did not help Mr. Avery. Rather, it ensured his conviction. Most importantly, the circuit court was not relieved of the obligation to acknowledge that Bobby has now been connected to material evidence in Ms. Halbach's murder. The Denny test only requires an inference that Bobby is directly connected to the murder of Ms. Halbach, nothing more. By having possession of Ms. Halbach's vehicle after her disappearance, the inference can certainly be made. The Sawinski evidence is being offered as evidence of the, air quote, missing piece. The direct connection between Bobby and Ms. Halbach's murder. Contrary to the state's and circuit court's positions, Mr. Avery does not need to prove Bobby's guilt of the murder beyond a reasonable doubt. We're almost done. There is a reasonable probability that presenting Mr. Avery's newly discovered evidence undermines confidence in the outcome of Mr. Avery's trial. The state erroneously contends there is, quote, no possibility that any jury hearing it would have a reasonable doubt about Avery's guilt, unquote. The state claims that even if Mr. Avery met the Denny and Edmonds standards, he has not explained his DNA on the hood latch of the RAV4. Mr. Avery has always contended the hood latch swabs were substituted by investigator Wiegert for the illegally seized groin swabs taken from Mr. Avery on November 9, 2005. The state incorrectly contends Mr. Avery fails to address its trial expert's testimony that there was, quote, a fragment from virtually every bone in the human body being found in his burn pit, unquote. Mr. Avery did address this issue. The state incorrectly contends that Mr. Avery does, quote, nothing to explain how Bobby could possibly be responsible for the bullet with Ms. Halbach's DNA on it being found in his garage and matched to the gun above his bed, unquote. As stated infra page 7, Mr. Avery also addressed this. The new evidence would have allowed the defense to impeach Bobby's trial testimony. Bobby would no longer be the, quote, unbiased witness, unquote, described by Prosecutor Kratz, Mr. Sweaty Sweat. The forensic evidence would have been viewed as planted, or at the very least tainted, by being in the hands of a third party. With the new evidence, the defense could have argued Mr. Avery returned to his trailer, Ms. Halbach left the property in her vehicle, and Bobby followed her, got her to pull over, and assaulted and murdered her at some point. He planted the RAV4 on the Avery property and proceeded to remove and plant the electronic devices, the key, the bones, her clothing, her DNA on the bullet, and Avery's blood. The Sawinski evidence, when viewed in the aggregate, including all of the false statements made by Bobby to law enforcement and at trial, would have provided a reasonable probability of a different outcome at trial. Contrary to the state's position, the circuit court's inaccurate factual findings are material because they impose a higher burden on Mr. Avery. The state defends the circuit court's erroneous reliance upon Brendan's air quote confession, even though it is not part of the Avery record. The state claims Brendan's air quotes confession, quote, is a fact Avery must account for to show a legitimate tendency Bobby committed the crime, no matter whether the state introduced it at the last trial, and Avery failed to provide any facts explaining why or how Bobby Dassey could be responsible for Brendan's confession, unquote. Brendan's confession directly contradicts the state's theory in Avery's trial, and that is why the state did not introduce it. The lack of forensic evidence refuted Brendan's story of Ms. Halbach being bound, beaten, stabbed, and cut in the Avery bedroom. Brendan's story had multiple versions of where Ms. Halbach was shot. The state, by making this final argument, is trying to avoid the simple, undisputed fact that Bobby was in possession of material evidence in the case, the RAV4, and that this fact directly connects him to Ms. Halbach's murder. Mr. Avery has met the materiality requirements of Denny, Edmonds, and Brady, with a footnote. And the footnote says the circuit court correctly found that Mr. Avery's evidence had met the first prong of Brady, that the prosecution suppressed the evidence with the new Sawinski evidence. Conclusion: Mr. Avery respectfully requests that this court grant him one of the following alternate remedies. 1. Review the orders denying reverse the orders denying post-conviction relief and grant an evidentiary hearing. 2. Reverse the judgments of conviction and the orders denying post-conviction relief and remand for a new trial. 3. Grant any other relief this court deems appropriate. Dated this 14th day of May, 2024. And then electronically signed by Kathleen and Stephen Richards.